Hello and welcome to the July 2025 edition of Outline DLA Piper's regular planning law webinars. My name is Trevor Ivory. I'm a partner in the planning team here at DLA. I'm joined today by regular Outline contributor, my colleague, legal director in the team, Ian Graves. Morning, Ian.
Hey, Trevor. Great to be here.
On a very hot Thursday in July. Well, before we begin, just a quick rundown of the format for anyone that hasn't joined us before. We will aim to be about 45 minutes, definitely no longer than an hour. We always pride ourselves on not keeping you beyond the advertised 11 o'clock. As we're going through, if you're watching the live edition, there is a Q&A function. Please do, if you've got any questions, put them in there and we will try to answer as many of them as possible. Obviously, if you're not on the live version, probably don't bother because we're not going to be there to answer them for you. But the topic for today, we're going to look at the interesting topic of alternatives and the role that alternative schemes and alternative options play in planning decision making. And we're going to look at that through a number of different perspectives. But I suppose sort of Ian, kind of have to start with alternatives. You've got to go back to the heady days of the 1980s and the Trust House case, which basically said you don't consider alternatives in the context of planning. So this could be the quickest outline seminar we've ever had, because that was what the Trust House case said, wasn't it?
It was, although, you know, as viewers will know, in law, it's never that simple. Yeah, I mean, you know, this is one of my, I find one of the most interesting topics actually in planning law, because this point about consideration of alternatives comes up in, you know, in lots of different ways. And I mean, the starting point, as you say, was established, I think it's back in about 1987, certainly late 1980s in the Trust House Forte case. And that effectively said that as a sort of general rule, if you've got an acceptable development in planning terms, the fact that there is another option, you know, another site, for example, that would be more acceptable, it generally is irrelevant. But of course, what it did say is that, you know, there may be specific circumstances that mean that, you know, that you do have to consider alternatives. And I suppose, you know, the first of those situations would be where planning policy, for example, requires that you take that into account. So, I mean, you know, there are some examples around, for example, flood risk. You know, so the sequential test in flood risk requires that if you've got a development that's going to be on or partly on a site that's at high risk of flooding or at higher risk of flooding, you have to demonstrate that it can't be put on a site with lower flood risk. So that's an example of how a planning policy might push you down into a situation where you have to you have to consider other alternatives and possibly demonstrate that your development can't go on one of those alternative sites, for example.
Yeah, absolutely. And I think just sort of coming back to the Trust House Forte case, just briefly, I think the logic behind that case is absolutely sound. Planning is not about perfection. You can't refuse a scheme because it could be better. If the scheme is acceptable in planning terms, then the scheme gets planning permission, whether you would prefer it to look differently or otherwise. And I think that's kind of effectively, it's that fundamental concept of planning that feeds through for me in the Trust House Forte case, in saying if the scheme is acceptable in planning terms, then the scheme is acceptable in planning terms. If it might be better or otherwise provided elsewhere, that isn't a reason for.
It's about sort of predictability, isn't it? You know, so I mean, and ultimately, you know, the test is about whether it accords with the plan. You know, so it's acceptable, not perfect, isn't it? Is the sort of way that the planning application should be judged.
Sorry, I didn't mean to interrupt you.
No, carry on. I'd finished.
So I think kind of if we start with the 1990 Act, because there are differences between 1990 Act and sort of DCOs under the 2008 Act. And with the 1990 Act, you're right. You've talked about flood risk, but there are many examples, I think, where alternatives are an analysis of alternatives is required by policy, and in those cases, obviously that is an exception to the Trust House Forte principle. flood risk is a really good example. You've already talked about that. If you're in a higher flood risk area, you need to show that the development couldn't be accommodated in lower, and that there's a reason for it coming forward in that location. I kind of think there's a few other examples as well. I mean, I'm sure anyone does very much retail planning anymore, but it's still there a little bit, isn't it? But retail is that sequential test. Alternatives is very much at the heart of that idea that you can't put retail out of town or even edge of town if there's a town centre location. You very much have to demonstrate, if you're looking to be at the sort of the lower end of that hierarchy, if you're looking for out of town development, one of the things you've got to show is that there is a need for that development, and that development could not be accommodated on a site that is better located to the existing retail core of a settlement. So I think that for me is a sort of classic alternatives example.
Interestingly, a lot of the cases actually are from the sort of late 2000s, early 2010s that deal with alternatives are relating to retail, usually supermarkets. So there are several cases that deal with that. And, you know, it sort of demonstrates the point that you're making, that sort of sequential test makes obviously alternative sites highly relevant.
That was the great era of the store wars, as it was called, wasn't it? When
I think every planning lawyer has got a
planning lawyer was making money out of supermarkets, judicially reviewing supermarkets for their own commercial advantages. Had frankly nothing to do with planning at all. They just didn't want competition, did they? But yeah, a lot of those were then about actually whether there was need for those sites, and if there was need, did it have to be there or could it be somewhere else? But yeah, the store wars are fruitful in the alternatives case law that's there from that time, as you say. I think another one that's sort of much more relevant probably today, because retail planning is not very much retail development is coming forward, although clearly some is. But one that comes up all the time is greenbelt, and I think sort of greenbelt in the context of if you're trying to show very special circumstances for development, and particularly if those very special circumstances are about meeting an unmet need, whether that's for housing, whether it's for data center or for anything else. If you're going for an argument that you should get planning permission in the greenbelt because there is an unmet need, you do have to consider at that point whether that unmet need, once you've established it, could be met elsewhere outside of the greenbelt. And I think you see many cases and many appeal decisions where that exploration of alternatives is happening. And possibly, I think for me, even more so now with the sort of the NPPF's move towards a sort of broadening of the definition of previously developed land, the introduction of the concept of grey belt. Again, I think that's going to bring more debate about alternatives. If you're looking to be in the green belt, you will need to show that there aren't grey belt alternatives, there aren't previously developed land alternatives, and there aren't alternatives out with green belt entirely. I think we'll see that with us for a long time to come, as we have done in the past.
Yeah, I think that's right. I mean, I suppose, you know, going back to the Trust House 40 case, one of the things that was specifically identified in that case was where there's some identifiable planning harm. You know, if you've got some planning harm that's been identified from a particular development, then obviously if there are alternatives that would avoid that harm, then they do become material. And a good example of this would be something like heritage, or perhaps harm to an AONB. Those sort of situations. Heritage is a really good example. And in those kind of situations, if you've got a development that is going to cause identifiable harm, but there is an alternative that would avoid the harm while still, achieving the objective of the development, that is material, something that the decision maker needs to take into account. And a good illustration of that is the Stonehenge case that was, I think it's sort of 2-3 years old now, Stonehenge number 1. So there's been a lot of litigation around the Stonehenge DCO. So, this is a Planning Act 2008 case in relation to a nationally significant infrastructure project. But the same principles apply to Town and Country Planning Act. And in that case, so the National Highways was promoting a new motorway that would, so the idea is that it would replace the existing road by tunnelling under Stonehenge, and it would improve or reduce rather impacts on Stonehenge. And the issue in that case was that there were objectors who were arguing that, even though there would be an improvement, there was still harm to Stonehenge, and there were ways that could be avoided. And they proposed, for example, a longer tunnel that would, completely remove the harm, or even another road that sort of went in a different route entirely. So the Secretary of State in that case didn't give sort of a thorough consideration to those alternatives on the basis that National Highways had previously done quite a sort of lengthy optioneering process, and there was something called the Road Investment Strategy, which was the government's sort of strategic look at what highway development should take place. So the Secretary of State relied on that. And in that case, the court quashed the DCO decision and said, look, when you've got a situation where there is identifiable harm, and in fact, the Secretary of State accepted that, the preferred option, the promoted option, did have it did cause some harm to Stonehenge. When you've got a situation like that, if there are alternatives where that harm could be avoided, then they are obviously material to the decision, and it's unlawful not to take them into account. So I think that's a really clear example of the sort of situation that Trust House Forte was talking about, where you have a development that causes harm. You have to think about, is there a way that I can achieve the objectives without causing that harm?
I think you've mentioned it was a DCO under the 2008 Act, but I think it's a case that is very relevant to the 1990 Act as well, and that heritage issue that's at the heart of it. It's sort of Stonehenge is a United Nations, a UNESCO World Heritage Site. It sort of sits at the top of the tree in terms of heritage assets, and the principles I think that the court was looking at effectively, sort of in a nutshell, on alternatives. So I think for me, what the court was saying was, if you are causing significant harm to a heritage asset, particularly World Heritage Site or a listed building conservation area, a designated heritage asset, as the NPPF calls them, if you're causing significant harm to that asset, and especially if that harm is irreparable, which quite often it is with something like a heritage asset, or indeed damage to an AONB or whatever, another sensitive location. If you're causing that significant irreparable harm, then what the court says is then you are under a duty, notwithstanding Trust House Forte, you are under a duty to look at alternatives. And the court didn't distinguish between 2008 Act and 1990 Act. So I think it's a case that if you're doing sort of your traditional 1990 Act planning, you still need to be very alive to that. If you are causing significant harm, and that was in the context of EIA development as well, which we'll come on to. But I think the principle applies generally. If your application is causing significant harm to a sensitive site, whether that's heritage, ecology, whatever, then you are under an obligation to consider whether that development could be achieved in a different way, so as to avoid or reduce that significant harm. And that for me is the kind of real core of the case, which is applicable, doesn't matter what kind of planning you're doing.
Yeah, I mean, and it makes complete sense, doesn't it? I mean, if there's a way that you can avoid the harm, then you should consider doing that. I mean, the interesting thing in that particular case, I guess, was that there had been an optioneering process before the DCO was actually the application was lodged. So actually quite an extensive optioneering process, but the road investment strategy, for example, was a more economic sort of investment focused optioneering process. So it hadn't considered all the factors that would be relevant in a DCO application, for example. And of course, by the time the application came to be considered, both the examining authority and the Secretary of State had assessed the application and found that there was harm. So that just made the situation slightly different to the situation that pertained when the optioneering was undertaken. So it's an interesting case. I mean, I really recommend, if you're interested in this topic, to go and read that judgment, because it does go through in quite a bit of detail all the relevant case law, which are all 1990 Act cases, as you say. So it shows that the decision making the decision-making factors and process are no different under each of those systems.
And it's worth saying the court upheld Trust House Forte, so that general principle still applies. They didn't overrule that principle, but this is effectively an exception to it, is where you are causing significant harm. Now, a lot of the time, you won't need to worry about alternatives because you will have avoided that harm. And most responsible applicants for planning permission will have come forward with a scheme that does mitigate the harm. This is the situations you find yourself in where you've got to do the development. There's a need for it. There's a need for it in this location potentially, but you simply cannot avoid causing a significant harm, as the court was at pains to stress. It's in those circumstances.
There generally is some overriding reason, isn't there, why you need to cause the harm, and you're balancing it off against some other factor like need, as you say.
Yeah, and I think it's important. The court's not saying if there's an alternative, you've got to take it. The court is saying you need to have properly considered the alternatives. And one of the points I think comes out of the judgment for me is ultimately the level of detail you go into in that assessment is a matter of planning judgment. The court wasn't, was sort of reluctant to get involved in that. It was saying decision maker needs to decide how much information alternatives they need, and ultimately whether the application before them or an alternative is to be preferred is again a matter of planning judgment. So it's not an automatic, oh, there is an alternative, therefore I'm not going to get my permission because I could have done something different. That isn't what the court was saying at all. It's simply saying, as is so often the case with planning, it's a material consideration that needs to be in the planning mix. The weight that is attached to it, ultimately, as long as the decision maker is not acting irrationally, that weight to be attached to it is a matter of planning judgment, and the courts won't tend to interfere with that. But it's important that they're on the table and taken account of appropriately.
Yeah, and pretty typically in this sort of situation, the kind of things that are being balanced are, so for example, in the Stonehenge case, the longer tunnel option would have cost significantly more, for example, and that it's perfectly acceptable for the decision maker to weigh those two things and say, well, it wouldn't be feasible to do a scheme that costs double, for example, to avoid the level of harm that I've assessed. So as you say, I think provided that there has been a proper consideration and an explanation as to why the preferred option's been chosen. I mean, it's completely within the gift of the decision maker, and the court was quite clear about that, as you say.
Yeah. We probably ought to move on because we could talk about that all day. But I always feel whenever we did talk about the Stonehenge case quite a while back now on an outline when it first came out, and I said the same thing then. But I always feel the need to say I always feel very sorry for National Highways on this one, because actually National Highways were trying to tell the inspector to do this.
Yes.
The inspector simply refused to do it, and then as a result, National Highways got in trouble, of course, with its DCA. So in case there's anyone from National Highways in the audience, we have huge sympathy for you, because it wasn't the fault of the decision maker. And I think there's an important point there as well, which is if you're the applicant for planning permission, you've got to make sure that the decision maker, whether it's the planning authority, the planning inspectorate, or a Secretary of State, you've got to make sure, to the extent you can, that they are properly taking account of alternatives, as with everything else, because if they fail to do it, it's you that ends up losing out, as National Highways did in that case. So yeah, sympathy to them, and a warning to us all to kind of try and guide the decision maker to properly take account of this and everything else they need to properly take account of. But I think let's move on. That sort of probably segues us quite neatly, as I say, into the 2008 Act, and it is different in the 2008 Act, isn't it? Most DCOs, whereas most planning applications probably don't worry about alternatives, most DCOs do, and there are a couple of reasons for that, aren't there? Obviously, firstly, they are much bigger projects as a rule, and therefore they are likely to have greater magnitude of impacts and greater potential for those impacts. So I think that's sort of just a factual point. But actually, there's a policy point as well around how the national policy statements that govern the determination of DCOs work, isn't there?
Yeah, that's right. I mean, as you say, I think the issue of alternatives is highly relevant to most NSIPs. And part of the reason for that, like you say, is because they will all be subject to EIA. We'll talk about how alternatives are relevant to that shortly. And obviously, there's the statutory requirement for consultation, and alternatives are also relevant there. But the national policy statements tend to be more prescriptive in terms of how the decision-making process is done and the things that are to be taken into account. Under DCO, that the policy is much more prescriptive than it would be in relation to, say, a local plan or even the MPPF. So most of the MPSs will actually sort of walk the decision maker through, the applicant through rather, what it should do in terms of alternatives. And generally, they're just reflecting the existing law, so they will reflect the Trust House Forte principle that we've just discussed there, but also obviously, that there are the environmental aspects and so on that need to be considered as well. So, it's the same fundamental principles, I would say, but it's just made more explicit in DCO practice. And then there is another layer of considerations in relation to the environment and consultation and so on. I think we're going to go on to talk about next.
And I think probably the other point that makes it more live, which again is not so much a legal point, it's just a reality point. When you're dealing with an NSIP, with a big infrastructure project, it tends to generate more views in the public that it could be done in a different way. One of the ones that springs to mind is new power lines. Immediately you're faced with local people who would prefer to see those power lines undergrounded. And so just almost by definition, alternatives is coming through in the public consultation as well as coming through from the legal perspective, where people will be proposing other ways that the infrastructure could be delivered with less harmful impacts as they would see it. So I think that's, for me, you've got the policy requirement in the NPS, but you've also got just a public who, it is less common for someone to say, well, we need the housing, but it shouldn't go here, it should go there. It happens, but it's less common. Whereas I want that pylon undergrounded, or I'd like that railway line to go to the north of the settlement rather than the south, assuming you live in the south. Those sorts of issues are much more live, I think, in the objector's mind.
They're much more salient, aren't they? And I mean, as you say, I think, but the key issue is the projects are just bigger. So they affect more people. There will be more people engaged. I think particularly with linear schemes, also there just are a lot more options. So you've obviously used the example of undergrounding. The equivalent to that in a road or a rail scheme would be putting it in tunnel. And we know on HS2, for example, there are quite significant lengths of track that have been put in tunnel to avoid impact. So, there are always these sort of arguments put forward by consultees. And that's why I was mentioning earlier on about cost, because obviously cost has to be balanced off against these sort of considerations, because putting something in a tunnel is significantly more expensive than having it on the surface. So I think you're right. There is just that sort of basic factual point that these schemes just have different impacts than, say, a housing scheme.
And as well as sort of the traditional objector, there is also a bit of coming back to the Stonehenge Wars point we made earlier. The one that springs to mind is airport expansion a few years back, where it wasn't just objectors around Heathrow who had strong views on whether there needed to be a third runway at Heathrow, but actually Gatwick, Manchester, other airports also had strong views on whether the right solution was to increase capacity at Heathrow or whether it was to do it elsewhere. So again, you've got actually sometimes quite well resourced commercial objectors with a stake in the outcome who will have a view. Certainly, and that's more at the NPS stage, when that was kind of the airport's capacity NPS was coming through. But yeah, another example where those tensions bring alternatives to the forefront and make it a material consideration.
Yeah, I mean, alternatives were highly sort of relevant, weren't they, to the airport's NPS, particularly because it's obviously a massively important commercial issue for a lot of parties beyond just Heathrow Airport. But yeah, I mean, I suppose that moves us on quite nicely, doesn't it, to environmental assessment, which is another way in which alternatives can become relevant. And I think, I think that this is something that is where there is quite a distinction between sort of most Town and Country Planning Act applications and NCIPs, because all NCIPs will require an environmental statement. Not all Town and Country Planning Act applications will require an environmental statement. So, it is something that is a bit different between the two regimes. But I suppose the thing I just thought we should draw out is the difference between the way, or the obligation in relation to alternatives, in relation to the different types of environmental assessment. So, if you look at environmental impact assessment, which is probably the thing that most viewers will be familiar with, the requirement there is to describe the reasonable alternatives that you actually considered and explain why you chose the selected option. So it's a sort of information requirement rather than requiring you to generate new options. Whereas something like strategic environmental assessment, so this is where you're doing assessments at sort of plan level, the obligations are much more onerous because you're actually required to investigate what other options there are. So, sort of generate those new options and then also assess them, to the same level as you do with your chosen option. So there is quite a distinction there, and it's a much more onerous obligation when we're in an SEA context to an EIA context. Obviously, SEA is much less commonly encountered because it is sort of strategic plan level stuff.
Yeah, it doesn't tend to hit those applying for planning permission, does it? It hits those who are trying to set policies in the first place.
Local plans are a good example, aren't they, of the...
I was just about to say, I think local plans is a good example, and it does then become relevant to those who are promoting specific developments, because the soundness of the plan and ultimately the lawfulness of the plan depend on the local authority getting that assessment, that strategic environmental assessment right. And quite often there's a sort of regular churn of case law where SEA is the reason that a plan is quashed because of a failure to properly assess alternatives. And I think you see that really, really frequently in local plans. And I think I sort of understand why, because I think you spend so much time with your local plan. That's the direction that you're going in. That's the direction that politically you want to go in. It's the direction that you're traveling. It can be quite hard to sort of stop at those points where you have to do the SEA, actually stop and apply the same level of thought to, well, what if we didn't put it here? What if we put it there? Or what if we dispersed it, or whatever it is? Actually, that's quite a difficult thing to do because you're wedded to your plan by the time you've got to that point. But also it's very resource intensive, because I think a key point for me is you've got to give the same level of scrutiny to those alternatives. It's not a sort of a tick box exercise with SEA. You've got to properly go through the process and have properly considered whether there would have been a better way of doing it, a less harmful way of doing it if you'd not expanded that settlement, but allocated growth to that settlement, all those sorts of issues. So I think it's one that if you're looking to try and promote through plans, you do, again, coming back to that, trying to make sure the decision maker gets it right, so that you ultimately don't find yourself in difficulty once you've got your allocation, only to find the plan is quashed because your allocation was unsound, because the alternatives to it haven't been thought about. You find yourself in that difficulty, but one that is regularly got wrong in my experience.
Yeah, I think that's right. I mean, I think part of the issue is that sort of practitioners are just less familiar with SEA. So so it is kind of easy to get wrong. I mean, I suppose just to sort of calm any worries for people watching, it's not any possible alternative. It's only reasonable alternatives. So the courts have been very clear on this, that things that are obvious non-starters, don't have to be assessed. So it is only the reasonable alternatives that would fulfil the objectives of your plan or program that need to be assessed. But I mean, I've got quite a bit of experience of SEA particularly, and I mean, well, my experience on this is that, generally actually alternatives have been considered to quite a, quite significant level of detail, but often it's just not made express in the process. So one of the things is just about, documenting that properly so that, it's clear that that has been done. And I think, the courts are going to be reluctant to start getting involved in the sort of technical decision making about why one option has been discarded versus another, as long as it is clear that the decision making process has properly generated the alternatives, captured them, and there's been a sort of structured process to whittle down to your preferred option. I think courts are very unlikely to interfere in that sort of situation. And then in terms of the assessment, I mean, obviously, environmental assessment of multiple different options is pretty onerous, but we are at the strategic level with SEA, so the level of detail that's required is going to be less for a start. And also, it only needs to be done to the level that is appropriate and reasonable for the status of your plan, if you see what I mean. The other environmental issue I just wanted to raise was around habitats regulations.
Just before you do that, just one more point, if I can, Ian, on SEA and EIA. I think the other thing always to bear in mind is that they're an ongoing process, and probably local plans and SEA is the best example of that again. But during the course of an examination of a plan, the plan will change. Inevitably, and you will often see, almost always, you will see the planning inspectorate having completed an examination, proposing their main modifications. They will then require the planning authority to go back and redo the SEA to recognise the fact that actually what was assessed before is no longer the plan, and to take account of those modifications and to look at the alternatives to those modifications. So it's just one for people to keep in mind as well. Because the same applies to EIA. If your scheme is changing through the course of this determination process, then that to the extent alternatives are relevant, you need to keep an eye on whether the changes to your scheme you've made during the determination process actually mean that there are other alternatives that ought to have been assessed that haven't been. So it's just a point to keep in mind.
Yeah, really good point. I mean, actually, the two the preparation of the plan or the application and the environmental assessment actually should be informing each other, shouldn't they? So it really is a process. The outcomes of your assessments should be informing your consideration of alternatives and so on, as you said.
Sorry, I interrupted you. Habitats regs completely
habitats regs, so habitats regs are slightly unusual in terms of alternatives because the requirement is quite different. So I mean, in this sort of situation, if you've done your appropriate assessment and you find that the development will have a negative effect on the protected site, will harm the integrity of the protected site, in order to be able to proceed, one of the things that you need to show is that there are no alternatives. So you will need to have thoroughly considered alternatives. The way that the law operates in habitats regulations is there has to be a really high degree of scientific certainty as well in terms of the judgments that you're making. So, there will need to be an exhaustive process in terms of identifying what the alternatives would be, and you'll need to demonstrate that there is no alternative, as well as some other criteria that are sort of outside the scope of this talk. But it sort of flips around the question really. The obligation is on the developer in that sort of situation to show there are no alternatives, and obviously that's pretty rare because mostly we wouldn't bring forward. Most developers wouldn't bring forward a scheme that had that effect. But occasionally, if you've got something that's, there's a really sort of significant need for a particular type of development, then that it will happen.
Yeah, absolutely. And then we sort of move on to some of the perhaps less obvious areas where alternatives come in, maybe. And the first one of those I thought we could talk about is compulsory purchase, where the alternatives are relevant in terms of justifying the use of compulsory purchase powers. And so here, I think it's alternatives in a slightly different way. Quite often, it's not necessarily talking about does the scheme have to go here, because by that point, usually planning permission's already been granted for the scheme. But it's whether the use of compulsory acquisition itself is justified or whether actually the scheme could be delivered in an alternative way. You quite often see that if you have a large scheme, large regen scheme, and you've got a developer who already owns a part of it, that developer may well run the argument and is perfectly entitled to run the argument. You don't have to compulsorily acquire my land in order to bring this development forward. I can bring this part of the development forward, and I can do that. And that the fact that there is an alternative means of delivery means that the use of compulsory acquisition powers is not justified. I think that's one to keep in mind as well.
Yeah, I mean, I think that's completely right. I mean, this is quite a common, I would say, common issue at CPO inquiries. Is some variation on, you don't need to take my land. I think it's sort of it's a fundamental part, isn't it, of that question as to whether there's a compelling case in the public interest to give compulsory purchase powers over that land, is that really there is no alternative. And the government guidance on this is very clear, isn't it? That compulsory purchase should be a last resort. And part of demonstrating that it's a last resort, I guess, is that that there is no other way that you can deliver the scheme. But as you say, I mean, we were talking about sort of supermarket wars earlier on, weren't we? And again, I was involved early in my career in a couple of CPO inquiries where exactly the situation that you've just described, where one party owned part of the site and was arguing that it had an alternative scheme that meant that CPO wasn't required. So it's a really common issue. I think that the problem that often objectors have in this sort of situation is they've got to demonstrate that the objectives of the scheme can be met. So it's not just that showing that there's an alternative scheme isn't in a CPO context what you need to do. You need to show that the objectives of the scheme under consideration for the CPO could be met in a different way, and often that is quite difficult actually. If you only own part of the site, sort of by definition, you can't deliver the whole thing. And equally, there are other contexts that sort of argument comes up in. So I think it's very commonly run, that argument. I think it's much less commonly successful.
Yeah, I think one of the areas where you see it, and I've got one example on my desk at the moment, is in the context of a DCO, a commercial NSIP, a Section 35 NSIP. So something that has been brought voluntarily into the DCO regime as a big scheme, and there it's obviously a commercial scheme, as opposed to a power line or a railway line that people don't want to deliver a part of. But you potentially you've got to justify CPO powers if you're seeking them as part of your DCO, and in that situation, if it is a purely commercial scheme, and if you've got another commercial operator already owning part of the site, that's an example where I think it comes up, and where you may get your DCO, but you've got to think about whether you're going to get your CPO powers alongside it, and whether you can justify it and meet that very high test. And ultimately, it's right that compulsory purchase powers are a high test. It is a breach of our human rights at the end of the day. It's the state seizing our property. You've got to meet that bar, and the bar is quite high. So you're right. Quite often, in a sort of typical town centre regen scheme, where this quite often comes up, you will see it's quite hard, I think, to show that you delivering your part achieves the overall purposes of the CPO, because that might cause viability issues for the overall scheme or whatever. But it is a real issue, and one that needs to be thought about when promoting a CPO, whether it's standalone or in the context of a DCO.
Yeah, and at an early stage of the process as well, you have to really think about whether there are alternative ways, and also that you're taking the minimum amount of land that's needed for your scheme. And again, this is something a couple of things I've been involved with where the objection was really to the scale of the compulsory purchase rather than the fact of it. You see what I mean? So I've run arguments for clients that the developer was trying to take too much land, was trying to obtain freehold rather than when it only needed rights, for example. These sort of things are quite common. So you need to carefully scrutinise what the case is, in a CPO context, because those sort of questions are going to be absolutely sort of material to the decision-making process, and to you demonstrating that you meet that fundamental test for compulsory purchase.
And then the last area is really around sort of public consultation, which obviously is throughout planning. It's all about public consultation, isn't it? So it comes up in every conceivable aspect of planning. But in the context of, and here I'm thinking less of sort of the applicant's public consultation pre an application or pre a DCA. It's more about the sort of, it's about government consultation when it's formal consultation. There are some key principles there that require alternatives to be considered, aren't there?
Yeah, absolutely. I mean, I think this comes up in a number of different contexts, doesn't it? Obviously, you know, I think it would be more common in NSIP applications, because obviously you've got the statutory requirement to consult in relation to DCOs, and you know, often, you know, a lot of applicants will do non-statutory consultation before that as well. So obviously, if you undertake to consult, then you have to consult fairly. But also, as you say, you know, you have government consultations, you know, local authority consultations in relation to planning policies and those local plans, those sort of situations. So I mean, you know, it's absolutely goes to the heart of a lot of planning decision-making processes, I think, doesn't it? And I think the sort of important point here is in relation to what constitutes a fair consultation. So, you know, the law on consultation is very focused on fairness. So rather than prescribing a particular process, the law prescribes general principles, known as the gunning principles, around what makes a consultation fair. And one of the issues in relation to fairness is that consultees have to be given sufficient information to enable them to give an intelligent response to the consultation. So, you know, you haven't run a fair consultation if you don't give people enough information to allow them to, you know, think about your proposal and give an intelligent response, in other words. And I mean, one aspect of this that the courts have ruled on a number of times is in relation to information given about discarded alternatives. So a really good example is a few years ago, there was a case called Moseley, which is about local government budget cuts. And the local authority decided to do a consultation about this. And effectively, the way that it had presented the information in the consultation was that the budget cuts were basically inevitable, and that there was no real alternative to doing this. And what the court said in that case was that, you know, that was unfair, because consultees needed to know what the other options would be. So just as an example, you know, raising council tax would have been an alternative, and there were other alternative ways that they could have gone about. They could have cut different services. You know, there were different options basically that the council itself had discarded earlier on. But in order for consultees to sort of understand the process and to be able to make comments on it, they needed to know, you know, what the other options were effectively. And so obviously that's highly relevant in a planning context. You know, there will be situations where for a DCO application, for example, you know, you might need to show alternative routes or alternative, you know, means of doing the development that you've discarded, so that consultees have got that information and they can use that to sort of scrutinise your proposals.
And I think there's a case as well, isn't there, the Moseley case, which is quite interesting on the point.
Yeah, that's the local government point of it, the local government case I was just talking about. So about local government cuts, yeah.
Yeah. Sorry, I was just flagging it was the Moseley case. So, well, that I think is all the ways we could think of that alternatives come into the system. I'm not going to say that's all of them, because I'm sure someone will come up with yet another one that we haven't thought of. We have had one question come through, which is around going back to where we started actually with Greenbelt, and the question is saying, well, what if there are alternative sites outside the Greenbelt, but the overall need for development means you need the Greenbelt site and the non-Greenbelt sites, which is a good question. And I think the answer to that for me is I think at that point the alternative becomes less relevant. And I certainly saw this recently. I had a data centre appeal in the Greenbelt in Buckinghamshire at the back end of last year. I think we've talked about it on a previous outline, but there we were in the Greenbelt. In an early stage, by the time we got to the inquiry, the council sort of moved away from the point, but at an early stage in the process, the council was saying, well, it doesn't need to be in the Greenbelt, this could be accommodated elsewhere. But the reason that it went away actually was because what we were able to show in evidence that the council didn't contest at the inquiry was that the need for data centres was just vast and it's just sort of exponential even before you think about AI, but AI is just driving that curve even further up. The need for data centres was so much that even if you built on, and our evidence demonstrated very clearly, even if you built a data centre on every available site, we still would be nowhere near
more demand. Yeah.
So at that point, the council kind of backed off from the alternatives argument, and it didn't feature in the decision in the end for that reason. So I think that's kind of the answer to the question for me is ultimately a decision maker will have to decide what weight to attach to an alternative. And it seems to me the weight you attach to an alternative must be less. If even if that alternative comes forward, you'd still need this development. That must reduce the weight to attach. It's still a material consideration. It still needs to be thought about. And if you ignore it, then you ignore it at your peril, and you've potentially failed to take a material consideration into account and potentially risk a judicial review or statutory challenge. But I think if you considered it at a reduced weight on the basis that the need means both sides need to come forward, that seems to be is probably the answer that you'd get to through a robust decision-making process.
Yeah, agreed. I mean, they're often very fact sensitive, aren't they? These sort of judgments. But I mean, I think we've made this point a few times, haven't we, throughout the talk. Ultimately, as long as the issue is considered, it would be perfectly rational, wouldn't it, for a decision maker to say, well, look, even if alternative sites come forward, there would still be a demand for this particular development. So therefore, I'm going to reduce the weight of the existence of those alternatives.
It's if we've used one phrase through all the years that we've now been doing outline, if we've used one phrase more than any other, it must be that's a matter of planning judgment. I think it's going to be on my tombstone. It's a matter of planning judgment, because that quite often is the answer to everything in planning, isn't it? And I think that yes, the point that comes through in everything we've talked about today, alternatives need to be considered. But if you considered them, it's ultimately a matter of planning judgment. In almost every case, it's a matter of planning judgment, whether the existence of an alternative means that you don't get the approval you sought. That is planning judgment. There isn't a legal answer to that.
Agreed.
Well, on that note, we might just have another question come through. We have, so this one's in a heritage context. How is it determined whether the alternative imposes a different scheme? Can an alternative be rejected because it changes the scheme in a relatively small way?
Depends, I think, doesn't it? I mean, there's quite a bit to unpack in that question. I mean, in terms of alternatives, so it would be the consideration is whether it's an alternative that achieves the same objectives. So if it's not, it wouldn't generally be material, I wouldn't think, to say that you could just do a different scheme, because the scheme that's under the scheme is the scheme that's under consideration. I mean, I suppose if you're into sort of minor modifications to the scheme, then that becomes more relevant, I guess. But I mean, I think that is probably just part of the assessment of the scheme in question, isn't it? Rather than an alternative development. That's about how can your scheme be changed to make it more acceptable. Whereas I suppose what we've been focusing on is alternative sites, alternative forms of development, like tunnels versus overhead lines, those sort of things.
And it kind of actually, the answer is it's a matter of planning judgment, isn't it? Ironically, having just had that discussion, but I think the fact you'd have to think of a number of factors for me. Firstly, you'd have to decide whether the thing that potentially can be changed about the scheme is harmful. Is the existing scheme causing a harm? And then you've got to weigh in the balance how easy it is to make a change, what the other impacts of that change will be, and all of that will then have to be taken into account as a matter of weight, because ultimately you're not in that situation. You're not sort of, it's right back at the beginning where we began. The decision maker doesn't have the ability to say, I prefer this amended scheme, therefore I'm going to refuse you unless you make those amendments. The decision maker would have to show that without those amendments, the harm is such that it justifies a refusal, whether that harm is a conflict with policy or whether it's another material consideration. You've got to start with that, and only then would you sort of start to think about, well, then can I refuse on the basis you're refusing to make this change to the scheme? So I think
it's quite a nice sort of bookend that, because that's exactly what the Trust has for judgment said.
It's
an acceptable development, then there's no obligation to consider alternatives.
Good question. Thank you for that question, because that was a nice place to end. But we are comfortably within our 1 hour maximum, which I'm always take pleasure in. But Ian, thank you very much for joining me today. Thank you to our audience as ever. We take a break for the summer now. We give everybody a break in August, but we'll be back in September with our next edition. In the meantime, this will be available on our YouTube channel in a few days' time if you've enjoyed it that much to watch it again. But thank you all very much and have a great summer. Goodbye.
Thanks all.